In the United States Supreme Court, the case of Hollingsworth versus Virginia. The decision of the court in the case of Chisholm versus Georgia produced a proposition in Congress for amending the Constitution of the United States according to the following terms. The judicial power of the United States shall not be construed to extend to any suit in law and equity, commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. The proposition, being now adopted by the constitutional number of states, Lee, Attorney General, submitted this question to the court: whether the amendment did, or did not, supersede all suits depending, as well as prevent the institution of new suits against any one of the United States by citizens of another state. W. Tillman and Rawle argued in the negative, contending that the jurisdiction of the court was unimpaired in relation to all suits instituted previously to the adoption of the amendment. They premised that it would be a great hardship that persons legally suing should be deprived of a right of action or be condemned to the payment of costs by an amendment of the Constitution ex post facto, and that the jurisdiction being before regularly established, the amendment, notwithstanding the words, shall not be construed, and must be considered in fact as introductory of a new system of judicial authority. There are, however, two objections to be discussed. First, the amendment has not been proposed in the form prescribed by the Constitution, and therefore it is void. Upon an inspection of the original roll, it appears that the amendment was never submitted to the President for his approbation. The Constitution declares that every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or, being disapproved by him, shall be repassed by 2/3 of the Senate and House of Representatives. Now, the Constitution likewise declares that the concurrence of both houses shall be necessary to a proposition of amendments, and it is no answer to the objection to observe that as 2/3 of both houses are required to originate the proposition, it would be nugatory to return with the President's negative, to be repassed by the same number, since the reasons assigned for his disapprobation might be so satisfactory as to reduce the majority below the constitutional proportion. The concurrence of the President is required in matters of infinitely less importance, and whether on subjects of ordinary legislation or of constitutional amendments, the expression is the same and equally applies to the act of both houses of Congress. Second, the second objection arises from the terms of the amendment itself. The words commenced or prosecuted are properly in the past time, but it is clear that they ought not to be so grammatically restricted, for then a citizen need only discontinue his present suit and commence another in order to give the court cognizance to the cause. To avoid this evident absurdity, the words must be construed to apply only to suits to be commenced and prosecuted. The spirit of the Constitution is opposed to everything in the nature of an ex post facto law, or retrospective regulation. No ex post facto law can be passed by Congress. No ex post facto law can be passed by the legislature of any individual state. It is true that an amendment to the Constitution cannot be controlled by those provisions, and if the words were explicit and positive, to produce the retrospective effect contended for, they must prevail. But the words are doubtful, and therefore they ought not to be construed as to conform to the general principle of the Constitution. It is stated that a statute shall never have an equitable construction in order to overthrow an estate, but if the opposite doctrine prevails, it is obvious that many vested rights will be affected, many estates will be overthrown. For instance, Georgia has made and unmade grants of land, and to compel an effort to her courts is, in effect, overthrowing the estate of the grantees. So, in the same book, it is said that a statute ought to be so construed that no man, who is innocent, be punished or damaged, and no statute shall be construed in such manner as to be inconvenient or against reason, whereas the proposed construction of the amendment would be highly injurious to innocent persons, and, driving them from the jurisdiction of this court, saddled with costs, is against every principle of justice, reason, and convenience. Presuming then that there will be a disposition to support any rational exposition which avoids such mischievous consequences, it is to be observed that the words commenced and prosecuted are synonymous. There was no necessity for using the word commenced, as it is implied and included in the word prosecuted. In admitting this glossary, the amendment will only affect the future jurisdiction of the court. It may be said, however, that the word commenced is used in relation to future suits, and that the word prosecuted is applied to suits previously initiated. But it will be sufficient to answer in favor of the benign construction for which the plaintiffs contend that the word commencing may, on this ground, be confined to actions originally instituted here, and the word prosecuted to suits brought hither by writ of error or appeal. For it is to be shown that a state may be sued originally, and yet not in the Supreme Court, though the Supreme Court will have an appellate jurisdiction, as where the laws of a state authorize such suits in her own courts. And there is drawn in question the validity of a treaty or statute of, or authority exercised under the United States, and the decision is against their validity. Upon the whole, the words of the amendment are ambiguous and obscure, but as they are susceptible of an interpretation which will prevent the mischief of an ex post facto constitution, worse than an ex post facto law, inasmuch as it is not so officially rescinded or repealed, that interpretation ought to be preferred. Lee, Attorney General, the case before the court is that of a suit against a state in which the defendant has never entered an appearance, but the amendment is equally operative in all the cases against states where there has been an appearance, or even where there have been a trial and judgment. An amendment of the Constitution and the repeal of a law are not manifestly on the same footing. Nor can an explanatory law be expounded by foreign matter. The amendment in the present instance is merely explanatory in substance as well as language. From the moment those who gave the power to sue a state revoked and annulled it, the power ceased to be a part of the Constitution, and if it does not exist there, it cannot, in any degree, be found or exercised elsewhere. The policy and rules, which in relation to ordinary acts of legislation declare that no ex post facto law shall be passed, do not apply to the formation or amendment of a constitution. The people limit and restrain the power of the legislature, acting under a delegated authority, but they impose no restraint on themselves. They could have said, by an amendment to the Constitution, that no judicial authority shall be exercised in any case under the United States. And, if they had said so, could a court be held or a judge proceed on any judicial business, past or future, from the moment of adopting the amendment? On general ground, then, it was in the power of the people to annihilate the whole, and the question is whether they have annihilated a part of the judicial authority of the United States. Two objections are made. First, that the amendment has not been proposed in due form, but has not the same course been pursued relative to all other amendments that have been adopted? And the case of amendments is evidently a substantive act, unconnected with the ordinary business of legislation, and not within the policy or terms of investing the President with a qualified negative on the acts and resolutions of Congress. Second, that the amendment itself only applies to future suits, but whatever force there may be in the rules for construing statutes, they cannot be applied to the present case. It was the policy of the people to cut off that branch of the judicial power which had been supposed to authorize suits by individuals against states, and the words being so extended as to support that policy will equally apply to the past and to the future. A law, however, cannot be denominated retrospective or ex post facto, which merely changes the remedy but does not affect the right. In all the states, in some form or another, a remedy is furnished for the fair claims of individuals against the respective governments. The amendment is paramount to all the laws of the Union. And if any part of the judicial act is in opposition to it, that part must be expunged. There can be no amendment to the Constitution, indeed, which may not in some respect be called ex post facto. But the moment it is adopted, the power that it gives or takes away begins to operate or ceases to exist. The court, on the day succeeding the argument, delivered an unanimous opinion that the amendment being constitutionally adopted, there could not be exercised any jurisdiction in any case, past or future, in which a state was sued by the citizens of another state, or by citizens or subjects of any foreign state.